Test, test, test.
Yeah.
Testing. 9:30, we're out of executive session on number 25. 29, sorry, 29. I got a scribble on it. No action will be taken. We'll go back to 18. Presentation of certificate of compliance for Commissioners Court Leadership Academy to Commissioner Brandon Decker. Dr. Scuggs.
Good
Morning.
Hey, Matters. Looking, thinking on my way in this morning, it was a year ago this meeting that I was presented to y'all for to come to Walker County as extension agent. I think Decker and Chris, y'all were back here in the audience with me at that time. A year has gone by very quickly. Most of y'all here know what the extension service is, but we have a branch in the extension service called VG Young Institute of County Government. And I know we are well aware of that, but for the benefit of the audience here, they provide a lot of the continuing education units that the judge and commissioners and other county officials must have to complete the office they hold. So not only do they do that, but they also have a leadership academy. It is a more advanced training for leadership development. And one of our commissioners, Mr. Brandon Decker, is participating in that. It's a 2-year program. They have 4 meetings, 3 of them across the state of Texas, and then the final meeting is in Washington, D.C. And I think you're halfway through, Mr. Decker.
Right.
And to I guess to show your completion through session 2, you're halfway done. I've got a certificate here for you for completing 15 hours of educational training during the Commissioners Court Leadership Academy, session 2 in Corpus Christi. Not a bad place to go. Have to do some training. Not only is it suitable for framing, but we actually did frame it for you. So just want to present this to you.
Yes, sir.
Sir, absolutely.
Behind there.
I'm behind Brandon.
This way when y'all are down.
It's not hard to hide behind Brandon.
Hey, let's not hold up until.
I hear all that smack.
Thank you, Doctor.
Hey, we should be a
Number
nice-
19, discuss and take action to accept the election returns for the state constitutional amendment election held on November 7th, 2023.
That should be y'all motion on.
Yeah. I got it somewhere. Hold on. I'll make a motion to canvass the election returns for the November 7th, 2023 constitutional amendment election.
Second.
Moved and seconded. All in favor, raise your right hand. Motion carries. You want that, Gary? Number 20, discuss and take action to add a larger vent cap on the CSCD building to prevent wind-driven water from intruding, to be purchased with project funds. Harry?
Yes, sir. We have a proposal from DK Haney to install a larger ridge cap and replace all the screws in the field on the roof at the adult probation building. With the recent rains, heavy rains with the heavy winds that we've been having, water's been pushing into the ridge cap and getting the ceiling wet above the offices. When that happens, we have to go in, clean up, replace items, things like that. This could prevent a lot of property.
Not have a closure.
It has closures under it. We've tried that. It closes it off. It keeps the wind from traveling through, but the rain, the water makes its way in anyway, even if those are closed. This one, the way it's designed, this inlet would offset below the current inlet for the air. So we're hoping that the difference in the way the water would have to push itself up in there is hopeful that this could prevent that from happening in the future.
Did you
And you're replacing all the screws on that.
And
Yeah.
yes, sir, and replace all the screws,
on the entire roof?
the entire roof, yes.
Anybody got anything else?
No, I'm fine.
Back to my motion.
Second, 2 seconds.
Moved and seconded. All in favor, raise your hand. Motion carries.
Thank you, gentlemen.
Thank you, Larry. 21, discuss and take action to purchase a 410 P-tier backhoe loader through Sourcewell contract number G32119-JDC from Doggett Machinery Services for the amount of $171,268.
Morning, Cheryl.
Got it? Morning.
Yes, we had, or y'all had approved, on, November the 6th, to go out and procure, what Commissioner White was requesting. We went out and researched it and we did, procure it. Now we're asking, for you guys to approve it.
Make that motion to approve it.
I'll second.
Moving, seconded, all in favor, raise your hand.
Thank you.
Thank you.
Motion
Mr.
carries.
Thanks, sir.
22, discuss and take action on Microsoft Volume licensing renewal agreement. Dan?
Morning.
Morning.
All right, so every 3 years, we do a new contract with, Microsoft, via SHI. It's time for renewal again. Just to give you an update. Previously, the Microsoft license were split into 2 separate agreements, one for Dynamics and then basically one for everything else. We are working on combining that into one agreement, which should facilitate easier renewals in the future. We are technically still waiting on the official quote for this renewal, but we have received the paperwork and the terms of the contract for review.
And then you have this money already set aside.
Yes, there's funds set aside for the volume licensing and for the Dynamics portion. Also, just part of the issue with the receiving the quote is the transition from the commercial cloud to the government cloud. So we're trying to tweak the needed licenses for that transition.
That's a lot of reading. I'm assuming, Quentin, you've already. I glanced at it.
So I have a question. Since purchasing is not involved in this, as far as gathering the quotes and doing the contracts and keeping record of this, it does the court not feel like it is necessary for us to be a part of that?
I always feel like it's necessary for purchasing to be involved. So have they not been involved in
We have
this?
not been involved.
No, they have not been directly involved in this, other than getting the contract. We, and yes, they definitely need to look at it and go through, but this is a renewal of a DIR contract, but they definitely need to look through it. The contract was renegotiated in October, so what they have provided us is what you're seeing here, but they do need to review it and make sure they're in agreement.
Well, I would say we need to let it go through them before we approve it, yeah.
Can we do it subject to their approval?
Yeah.
The contracts expire November the 30th. We've had quite a difficult time getting what we needed, frankly, from SHI and getting the 2 contracts combined. The week we were really trying to get this accumulated was the week that purchasing was out, so we did not have them directly.
That would be my motion to
Yeah, definitely.
do it
subject to
contingent on purchasing plan that we're
I'll second.
following the rules that we should be following.
I'll second
And
that
our
motion.
recommended motion be to approve the Microsoft renewals under DIR contract DIR-CPO-5237, subject to review and approval by the purchasing department.
That's my motion exact.
That's my second.
That's your second too.
You get all those numbers, Karen?
DIR CPO 5237.
Yes, ma'am. Any other discussion?
Thank you, Ms. Cheryl.
CPO.
CPO.
I thought you said
All right, I got a motion and a second. All in favor, raise your right hand. Motion carries.
Thank you.
Thanks, Dan.
Dan.
23, discuss and take action on approval of projects within the city limits of Riverside to be paid for by the city of Riverside.
In the past, that had interlocal agreements with Riverside and various projects do them. The state requires that I bring them to court for approval. So these are the ones we anticipate doing over the winter and into the spring. So they're all broken out. So we will do the work, invoice Riverside at the prices that we show right here, then they'll check back to us. My motion is to approve agenda item 23 as presented.
Second.
I got some questions.
Yes, sir.
So what part of this is a government entity doing public work?
It's just
I got
interlocal.
conflict or doing bids on the chip sealing,
But we're not,
road grading.
no, we're not bidding it. We just sat down and this was the price that we worked up with them sitting there at the table. And if they want to do them, they can tell me we want to do them. And we just do one of these, the interlocal approval or the project approval from both sides, and we just go do it. It's an exemption that we have given to us by the state that a county can go into the city and do work, but it has to be approved at the county by the commissioner's court and the city hall, city council, and it can't exceed $15,000 per project.
That's
Bill, the only thing I had a question about was the crack sealing. When y'all do the crack sealing,
Mhm.
how do you charge for it?
We charge them by the blocks that we're going to put in. We kind of measure the street, the number of blocks, and then we measure the road. Like in this case, I think it's like some of them were like a half a day. They're kind of just short sections, but they have a lot of stuff in there. So
And that would go back
into my fund as other income or whatever like that. So it benefits them because they can get it done at a reasonable price, and it benefits me because it's over, most of stuff's over the winter when we have some slow time. We can go help them out, and it gives me some additional revenue that I can go do more stuff outside the county, outside the city limits also.
Well, you see where I'm going with it though. I mean, you're taking road, it's not your equipment, it's road and bridge equipment. And that's the reason I asked
Oh,
how it was built out,
oh yeah.
you know,
I didn't
I don't
know
have a
about that.
problem with it. I was just curious.
Yeah.
Yeah.
So, hadn't thought about that part.
It's like I said, there's nothing wrong with it. I just thought.
This one's fine, but somebody has to think about it.
Absolutely. Absolutely.
Anybody got anything else?
No, I think-
Moving second, all in favor, raise your right hand. All against. 4-1. It passed. I vote against. 24, discuss and take action on the purchase of iWork cloud-based software for the use of precinct 2 and 3 at the price not to exceed 18,500. Purchase price is not to be split evenly between, is to be split evenly between the two precincts and is to be paid using budgeted funds for the initial installation and setup and $11,500 annually beginning in year 2.
This is switching away from our used to be Dude, then it changed into Brightly program that we're using right now. A couple of years ago, they notified us that they weren't going to be doing any more enhancements to the program, but it was a good program, so we stayed with it. And then last year, they said they were taking away the GIS portion of it that we use pretty heavily at my precinct. So that was important enough to us that we kind of saw the writing on the wall that the program's going away. When they quit doing enhancements and they start taking pieces away from it, they really want you to get away from it. So anyway, so we looked around, shopped around, myself, Lucy, Ashlyn, and Ronnie, we shopped around, looked around and found this iWork program. We've checked a couple of the references, actually went over to Anderson County and sat down and visit with them. Pardon me?
Grimes County.
To Grimes County, went to Anderson in Grimes County. That's what we did. Thank you for that. And I think it's worth going for. We're going to pay for it from our own budgeted funds, kind of split it. And so that's my motion, is to approve agenda item number 24.
I'll second that. Ashland's well on board with what y'all are doing, so.
Awesome.
I'm good with it.
Moving seconded, all in favor, raise your right hand. Yep, purchasing.
Yeah, because I'd like to look at it if that's okay, being a software procurement, making sure that the rules for purchasing software is met. Department of Information Reach. So, and make sure it was followed correctly.
Let me amend my motion to make it contingent upon review and approval from purchasing department. And we'll keep you in the loop from here forward.
Thank
on
you
that.
so much. I appreciate that.
Second on that.
All in favor, raise your right hand. Motion carries. 25, discuss and take action on removal of cattle guard on Plantation Road.
We have a piece of Plantation Road, the far south end has a cattle guard was placed across it several years ago. We're getting ready to go in there and try to do some work on that road. So in order for me to remove a cattle guard, there's some rules the state has put in place, one of which is to notify each person down the road that's affected by the cattle guard 90 days in advance. So we have those letters written, ready to go out. And the second one is approval from Commissioner's Court. Pardon me?
They went out Thursday.
Okay, so they're out Thursday, then approval from Commissioner's Court to go remove the cattle guard. So my motion is to approve agenda item number 25 as presented.
I'm gonna give you a second to that.
A point of clarification, the cattle guard cannot be removed until the 90-day period is passed.
Right.
And if during that 90-day period, one of those landowners requests a hearing, there'll be a hearing.
They'll come up here.
Are there, sorry, did you send them certified bill like this?
Yes.
Yeah.
Yeah, and if my memory don't fail me, I don't think the county put that cattle guard in. I think
Yeah.
that an individual put it in on a county road.
Right.
And he did not get permission from the court.
Yeah, I initially started off with that, getting ready to snatch it out, but I figured it's worth a note to Quentin.
It is.
And he
I
slowed
just
me
want
down
to
a
point
little
that
bit.
out. You know. We're gonna follow the rules. He did not.
Yeah.
Any other
Appreciate it.
discussion?
Nope.
I got a second.
Yes, second.
Okay. Moving second, all in favor, raise your hand. Motion passes. 26, discuss and take action on the reappointment of Charles Deerwester to the Board of Emergency Service District 1.
All right, there's two people coming up, just on the natural rotation that we have every 2 years. Charles has been on there, a couple of terms. She is our existing sitting president. Since she's, been there, she, has just been rocking it for me out there, I guess, for that ESD there. She's went in and redid their inventory system, redid their asset tracking system, sat with every fire department, got all their stuff reportable, helped set up the new webpage, and has been an integral part of the planning going forward, and just been a rock for us out there. So I think it's important to me that I keep her on there to keep us moving forward. So that's my motion, is to approve.
You know, I can't help you with this one. You know, I'm against it. I normally take the commissioner's lead on this, but this one's different.
I understand.
And without giving a bunch of details, you know, circumstances here a while back, I just cannot go along with this.
I understand.
Yeah, I'm with Ronnie.
I'll give you a second, Bill. It's very hard to find people that will dedicate their time
For free.
for no money. And it does take up a lot of time. People don't realize these boards like this, what's entitled on them. So I'll give you a second.
Moving seconded, all in favor, raise your right hand. All opposed? Motion fails.
Do you think bells are passed?
Fails. Number 27, discuss and take action on the reappointment of David Price, the Board of Emergency Service District 1.
Make a motion to approve agenda item 27 as presented.
I'll second that one for you.
Moving seconded, all in favor, raise your hand. Motion carries. 28, receive an update concerning IT security matters. We're moving ahead with our cyber hack. Or whatever we're dealing with that, we're sending out letters to notify people. And Dan did a great job recovering information and setting stuff up and getting lined up. That was part of the 365, is to update our stuff to make it a little more harder to get to. He's increasing some security features we'll be coming back to. Got anything to add to that, Dan?
So we started doing a program with CISA that does a cyber hygiene vulnerability scan. So we set that up. We received a few reports that found some things that we need addressed, which we have already done that. So we're making some improvements, and the original vulnerability that led up to this incident has been patched and is no longer a concern at this time.
Awesome.
Anybody got questions? Thank you, Dan. Done 29, we'll move on to number 30, this planning and development, discuss and take action on Peach Creek, Texas LLC request for variance to section 3 of the Walker County subdivision regulations regarding assessment, transfer of plat number 22-037 submitted in 2022 to another entity within 36 months of the original submittal date for the proposed Peach Creek Forest subdivision, Jose Maria de la Garza, A22, State Highway 150.
You want it on the map?
Sure. We have received a variance request from the developers who have an open application in for proposed subdivision. The first of the request is that the owner is requesting the ability or the approval of the Commissioners Court to have the ability to assign or transfer plat application to a second party within the 36 months of July 22nd, 2022. Obviously a year ago, so this would leave a lot less time than the full 36 months for the transfer to take place. The developers here today. Well,
I don't have a whole lot to add other than normally when we're doing platting, well, the last step of the plat, as you guys are aware, is recording the plat and getting a subdivision bond. Most of the time, that's a seamless transition from one entity to the same entity. In a lot of cases, that other entity might be a different structure internally. It might be a different buyer that owns the property. And then the only modification that we actually end up making is changing the owner name on the recorded plat. And they are the owner that is actually bonding the subdivision. So I've never had an experience, quite frankly, where I actually have to assign the application. So that was a little foreign to me. So normally when I do it in any county, it's not an issue because there's not a requirement to transfer an application, nor is there anything that states that an application can't be used by another entity. So this is the first time I've had to ask to actually assign something. So our intention is to make sure that everything that we're entitling on the project and all the work that we've done, all the money that we've spent for engineering and platting and application fees can be assigned to whatever entity that is that takes the project and bonds the property and records that property under their name. So for us, it's just a formality and we want to do everything by the book. That's 100% our objective. And so we just are asking that we are allowed to at least transfer it to another entity. The only other alternative for us, which we don't want to do, is to sell our own entity to the other entity. It's a legal step we could do, but it just doesn't seem like it's really forthright to do that.
What was your name, sir?
Chris Wren, W-R-E-N.
Andrew, what's our policy state on transferring?
So in the past,
Or I'm sorry,
anytime
Peach Creek.
that someone wants to transfer an application, the only way they could do that is to come and get direct approval from Commissioner Court to do that. Our applications are, once they begin, the application is for who it is from, who it's from. We don't have any mechanism inside the code to allow for transfer of that permit. So the only way for me to allow it is to bring it to you. They would have to bring it to you guys like they've done through variance. You guys have to approve it.
All right, have we done any in the past?
Once.
Deer Forest?
Yes.
But we made them come in and sign a whole new application.
Yeah, so I would, no matter whether you grant, if the court chooses to allow, I would strongly recommend that the condition of that be that the applicant who the property is transferred completes all of our permitting paperwork and all the items that were assigned by the original owner. Absolutely. All of our permitting paperwork, all of our application paperwork would need to be executed by the new owner, because there's a lot of stuff in there about the procedures and the policy that the new owner needs to sign that they're aware of, just like the old owner did. So
Well,
any approval I would request to be contingent on all that the new applicant signs all permitting paperwork and provides all new items related to ownership.
Now, under Deer Forest, did any variances granted? They had to come back and get the variances again, didn't they?
They requested a transfer of the application and the existing variances.
I know they're asking that, but what do we do on Deer Forest?
So that's what Deer Forest requested when they came in. They requested a transfer of the plat application, the variances associated with it, and the development permit.
What did the court, you know what the
Is
court
this
done?
something that you're okay with, Mr. Renz?
Yeah, absolutely.
Yeah.
Actually, it reinforces the fact that whichever entity takes on the project, they want those assurances. They want to make sure that everything that we're getting approved for is transferable to them. So they absolutely want to abide by whatever those rules are, including a variance transfer. It would actually kind of defeat the purpose for us to go through this process and not be able to assign those, because then we would all be starting over. And in some cases, based on current regulations, it would negate our ability to do the project.
I don't remember how I voted on the last one, but I do.
You got it.
I did. Yeah, I'm sure I did. I don't know, but I can tell you, I don't like the situation. You know, I'm not saying yes or no, but
From the other item? Yes.
Well, we very much from the last.
Talking about from the previous time, the previous.
Yeah, I don't know. That's why I was asking, what did we do then?
well, I'm
Court
sure
would-
we let them have it. I mean, they move forward with it. So, I don't like this. I mean, I ain't saying yes or no yet, but I don't like the situation. I don't like when.
I don't like the situation either. And I don't like the 3 years, even though we're a year into this, you know. That we could have a whole different court because things change that fast. So I don't know. I haven't been sold on it myself either.
I understand your concern. The 3 years is, lack of a better word, insurance for us to make sure that we have a transferability that is still good. And I want to be completely transparent with the court. I own the property and I have this property under contract to sell. Okay. And their contingency is that we have this assignability. And so if they close in a few months, we're way under the 36 months that we're asking for. We're actually way under the 24 months. But I think you guys would all agree that anytime there's a closing on the table, nothing really happens until it actually happens, right? And my concern is if these people, for whatever reason, they don't close on the property, and I have to have another buyer buy this property, that I don't want to have to come back and ask for an extension. So in the real world, I'm looking at probably less than 6 months, and worst case 24 months. And so that's why we asked for 36, because it's backdated a year from the time of the application. Is there a time that you feel comfortable?
So I think we need to at least hold it within a year from this date
From
today.
I'm okay with that.
Well, that puts us a limit on there. That puts us where it'd be taken care of.
Right.
You're good with you?
Yeah, I'm good with that. We're only talking about section 1, which is already submitted, so I'm fine with it. Right now, we're just talking about the assignment of or the transferability of the plat application. Right.
It would be the transferability of the plat application, but to be clear, you just said we're only talking about section 1. What we're talking about this application transferable, not separately from the rest of the tract.
No, I'm saying that the first application that we filed, that we paid for, that's transferable.
That application,
Right,
not
not future, yeah.
But you're selling the whole tract line.
Yes, sir. Yes,
The
sir.
whole tract.
Yes, sir.
okay.
And we're
I just want to be
talking,
clear on that.
and I want to be clear too. We're talking about section 1 of this development.
Right. It's the only one that we've submitted, that we've made a plat application and paid for.
Our agenda item has section 3.
Yeah, this is section 3.
That's of the sub.
Variance for the
No,
that's the subdivision
regulations.
codes.
That's a
Yeah.
Okay. I'll make a motion to approve this variance to section 3 of the Walker County subdivision regulations regarding assignment, transfer, of plat application 2022-037, section 1 for 12 months from this date today.
For the plat application variances and permit application.
Plat application variances, yes. Permit application, section 1.
So you're giving the variances to go with it? I don't like that.
Well, we're fixing to
Got
talk
there
about
yet.
the grant, the variances.
Variances. We're gonna do it one at a time.
Down here.
Is that the next one?
He's talking about the variances already. Granted.
That's what I'm talking about, the ones that's already there.
All right, so let's discuss that. Yeah, it's already there.
So, trying to think. Got it. Existing.
Chris, you ought to know this. What variances are?
Stephanie, you there?
Yes, she is.
I don't know if I have any.
I don't think we.
Just want to double check.
Yeah. If I could, I think maybe this assignment maybe is out of order. In the list.
No, because if you're transferring it over, to somebody, we're giving you the right to transfer it over.
Yeah,
The variance have to go with the new.
I would agree. Maybe if you guys, if the intent is to transfer the variances with it, maybe we could table this item, go through the variances and then come back to this item.
That's to your point, is those are the variances that we don't have any variances yet,
That's what I thought.
and we're gonna ask for those next.
I would agree.
Yeah.
Maybe we could table this item. And
But I mean, his motion is to include any variances. So if we turn them down, they're not in there. If we
Yeah,
approve
right,
them, they're in.
granted, I guess, yeah.
Yeah, I'm gonna second your
Y'all
motion.
are fine with it.
I'm seconding the motion.
All right, we have a motion and a second. Any other discussion?
As long as the transfer is goes,
There's no existing variances as of now, right?
Correct.
as long as the transfer runs with the whole tract, right? So he's gonna transfer the ownership along with the application, right?
Of the, whatever,
To the new owner.
216 acres. Is that right?
You'll be transferring the application to the new owner.
Yes, sir.
Okay.
And 12 months, 1 year from today's date.
Yep. You got it? All right, all in favor, raise your right hand. All opposed, motion carries. 31. Discuss and take action on Peach Creek, Texas LLC request for variance to section B34.2 of the Walker County subdivision regulations regarding requirement for 2 fire apparatus roads for the proposed Peach Creek Forest subdivision, Jose Marina de la Garza, A22, State Highway 150.
Um,
So now we go to the map, Lucy. There we go.
Make sure there's not something on this. This is basically, we're keeping our two,
Scroll down. Please.
our
There you
two
go.
deals, but we can't get the width between it because of the depth of the lot.
So both roads will be constructed to subdivision standards. The issue that they're having is that we have a dimension ratio based on this total depth of track. And the frontage amount that they have available to them, they're having a hard time getting that to fit. So they're asking to spread them out basically as much as possible. This 2,030 feet as a variance.
Chris, have you got your textile permits or your entrance list?
We have conditionally received them. We made one application, and because of the west entrance, it was 113 feet too close to the crest of a hill. So they made us go a little bit farther. So that pushes us actually about 168 over to the right. And so we did a line of sight study with TxDOT. We did our traffic study with TxDOT, and they agree with these access points. So they conditionally approved us. The next step would be to give them construction drawings when we finalize section 1 construction drawings.
Now, the question I have is, it's in here as 2 fire apparatus roads. Explain to me what a fire apparatus road in your mind is for this.
So the way the reg reads is that the distances between the two access points, the two roads, cannot be less than half the distance of the length of the property. So that wording is a little odd because our length ended up, if we got the access road a little bit to the west, our length we were actually at 46.5% on the length, not 50%. But then when TxDOT said, hey, we need to move it over a little bit, then we came back to like, I think we're at 39.5 or something percent. So a couple things that we planned with this project, and just to clarify, for those that don't know, we have created mud district #1 on this property. So all of the roads will be curb and gutter, all underground storm sewer. All of the roads are
Hang on, go back. This, I'm pinning you down on this because I got a purpose for this. All of the roads are what?
concrete.
Okay, so both entrances are concrete.
All the roads throughout the whole property, yes.
Okay,
Right, and the entrance to the right and the entrance to the left are both collector roads and do not have any lots. There's actually probably a better visual on maybe our next exhibit.
I think one of the things Commissioner Decker's after is both of the access roads will meet the minimum road standards in the subdivision regulations.
Absolutely, and actually the new wider collector road standard. So in this exhibit, it's a little confusing, but none of these lots face this collector road. So this road all the way down to this point has no lots that are facing the road. Same with on this side too. So that was designed for access and safety and to isolate traffic off of the main collector road. And so that's what I also went over with Chance Gardner.
I don't know.
And we are doing fire protection throughout the whole neighborhood, and we submitted a plan for the water system for the entire 216 acres, even though it's going to take a while to build that out with fire hydrants every 500 feet.
Okay. So I'll make a motion to approve item 31 as presented. I'll give you a second.
So on the plans he submitted, they don't actually meet our requirements for plans review. So I submitted him a letter that we're not giving him a letter of no objection at this point until we can do a formal plans review on what he has submitted to us. Some of it, which tells me that it's not going to be maintained as a hydrant per what we need. We had quite a bit of discussion. Our letter of no objection, y'all do whatever, commissioner wants to do, won't come until we can do a formal plan review, which we have not been submitting those plans yet. That's kind of where the ESD.
But he's got to get this variance to be able to know what he can do.
Yes, sir. And we discussed that. I just wanted to let y'all know that we have not got the formal plans to actually.
But we're going to 100% meet the current regulations, subdivision regulations, and the ISD regulations, and all the code and everything, and things that say flush valves will say hydrants.
Yeah.
Yep, sir.
You make a motion.
Moved and seconded, all in favor, raise-
And I was fixing to say, there's a
Yeah,
caveat to this.
anytime you grant a variance, I always suggest you put a timeline on it. So grant the variance contingent upon the plats being filed within.
a year.
I'm giving you the chance when they take it.
Yeah, I mean, I think with the same application, I would, if you're comfortable with that, 12 months.
12 months.
Plat being approved within 12 months.
That's what I said.
Okay.
That's when
On plats being filed and approved within 12 months.
filed and approved or just filed?
It's already been.
Approved and filed, same thing. You guys approve it, then file it.
All in favor, raise your right hand. All opposed. Motion carries. 32, discuss and take action on Peach Creek, Texas LLC request for variance to section B 2.1 and B 2.4 of the Walker County subdivision regulations regarding minimum lot frontage and minimum lot depth average for the proposed Peach Creek subdivision, Jose Marina de la Garza, A22.
Where did I see the?
I got it underlined.
I'm not seeing it.
Right there.
Well, the term of the variance, it's in the D.1.
Top of
It's in
page
the
two.
application. Or
That's the part that caught my eye.
D,
So last sentence, section, second to last sentence in section,
Page 2 or 3,
I'm sorry, it's page 2.
page 2 of 3, correct.
very top.
Go ahead.
So the variance application here is, that they want to buy the lots. Lots having less than 80 feet. Our current requirement is 80 foot. When the initial application for development was submitted, I think we had a 50-foot frontage requirement. Our current minimum depth is 160 foot. The proposal is, minimum depth of 120 feet and a frontage of 50 feet. With the exception of lots, on cul-de-sacs and inside curves, which will have no less than 35. That's the variance request. Our standard was flat, even before our standard was flat. So let me walk you guys through this. We had a 50-foot standard in place when the initial application went in. We didn't have any contingencies in that particular code for cul-de-sac lots or inside curve lots. Okay. So we then moved to 80 foot. The application had been submitted previously for the property as a whole. The request is 50 foot and then 35 foot minimum frontages on cul-de-sacs and on inside curves. They want a 12-year variance. So that one section will be platted every 2 years. So there's two parts of this. One is to the frontage, but the second part is that they want to be able to develop the property, have this requirement be allowed on sections as they develop the property over a 12-year period. So that's stated in accordance with your wishes. So right now we have a single application. So just so the court wraps their head around it, if they move forward and develop the entire tract in one big development, then right now they're at 50 foot frontage, no more than 1 to 3 depth to width, 1 to 3 width to depth. The request is for a variance to use 35 foot in cul-de-sacs and on the interior curves on that development, but also the request is to allow the development of the tract, essentially additional applications to be turned in on this parent tract, to develop the property in sections, not one big development, but multiple sections, multiple applications, multiple separate projects. Okay. Now
go back to item, just to reiterate on item 30, the motion was a variance, section 3. That was the motion we approved just a few minutes ago.
that was for variances that would apply.
Now we're talking about the more sections and sections.
So right now, there really is only one development application. It's for the tract. So they have a development application for the whole tract. Okay. What they want to be able to do is to develop the tract in multiple sections. So have a project for the first one, come back and do another section, come back and do another section. What they are envisioning right now under the current, and nothing's finalized yet, the application's still in flux, but under the current sort of imagining, they are developing the lots up front with the infrastructure to supply the back lots, as far as the road widths and that kind of stuff. And then they want to come back and develop those later on. That would all be platted as part of the original development. It would just have a large acreage tract at the back. What they're wanting court's permission is to be able to continue these parameters through the end of development of the property, regardless of what the subdivision policy changes to, right? So they would accept other changes to the policies each time an application is submitted, correct?
Correct.
Right. So if you made other changes to the subdivision policy between now and section 2 coming in, they would accept those. But they're asking to lock down the frontage requirements and the depth width requirements for those other sections of the properties they develop. Does that make sense?
Mm-hmm.
So if you change subdivision policy next week, right, and then they turn in an application on section 2, they have to follow the policy when the application was submitted,
Except for lot size.
including lot size.
For 12 years.
What you're asking to is not to.
Yeah,
Right.
correct.
That's the way it is now. What he's asking to is the ability to submit a section 2 plat in 2 years on the same property. And be able to use these lot sizes and frontages. Regardless of what other changes you've made to the policy. So you're locking yourselves in for whatever period that you guys grant.
The issue is, and Andy hit on it a little bit, is that issue we're gonna put in, like a full wastewater treatment plant, that system is gonna be sized for the entire track. The collector road and everything will all be laid out to handle pods of lots based on this lot size. So if we go to section 1 now, and then we come back in 2 years or even 18 months or 12 months, in section 2, now something's changed, then it doesn't work with the layout. The other thing that we did, and I hit on a little bit earlier, is we always planned on having both entrances done in section 1. And that was for a couple reasons. One, for safety and access, but also to get that water plan and everything up there with the collector road. And I don't want to speak for every developer, but it's almost impossible to develop a neighborhood with 50-foot lots in one section at the front and then do 80-foot lots on the rest of the section. It's just not going to ever happen. Nobody's going to do that. There will be larger lots in this subdivision. There will be. There will be probably 60. There will probably be 70-foot lots in this subdivision. But it's really hard to determine what those phases will be and when they will be there or what sizes they will be, because section 1 drives it. If we start with 50-foot lots at section 1 or even do 60-foot lots, the next section may be 70s, maybe 50s, and there will be a variety. And that's why this is a master plan concept. But just to plan for everything to be at 80s, it negates the deal. So our application was submitted under the governance that it was a 50-foot lots, but nobody's going to come plat 745 50-foot lots, or at least nobody I know. So we're just trying to plan the whole community long-term and be able to plan those as pods with the right size lots. And we want to go, what we're asking the court for is to go by the lot sizes that were in place when we submitted our plat. One thing I want to point out is, although we are asking for the variance on the frontage of 35 feet in the cul-de-sacs and interior curves, that's we did specify that at the build line where the house is, it would be 50 foot. So this is just where we have pie-shaped lots.
I mean, the lots we anticipate.
Well, this
for the variance, the depth of width.
how many total lots?
Yeah.
That land plan has 745, which I think is a little high. It's probably less, more like 650. But there will be even less lots if and when we do 60-foot lots and 70-foot lots.
You know, I understand the cul-de-sac and the adjustment that with the variance we grant there. I get that. What I'm leery of is curves and knuckles and things of that nature, because I don't have a set of plans to look at. I've got a conceptual drawing. We don't have a set of plans to look at to say, hey, this is what we're working off of, right? So to grant you a variance off of that, if I'm not for that, because we could end up with a snaky road to get more smaller lots or manipulate that decision that we're going to make.
On the current plat that we have submitted, it probably only affected 7 lots out of 180. And they were where we had a very wide curve, and the lots on the outside of the curve all had huge pie-shaped front lots, and the ones across the street had less than 50.
Yeah, I'm not against it, but I want to see it.
Right.
I want to see it on paper so that we know what we're looking at. The cul-de-sacs, I get that. That's We do that quite often.
I mean, we can adjust the curves. I'm not sure how we can put it into this, to this variance.
Well, I asked how many lots. Put a variance in there. I mean, you can put a condition in there to cover 10 lots, right, Andy?
You could.
Up to 10 lots. I mean, it gives you options.
Okay.
You know, I mean, if you're saying there's 7, then if Brandon's willing to go with that, then.
Well, that's the first section. So
Yeah.
could we do a percentage? Because we're talking about 6 sections, which over time might not even be 12 years. I hate even saying 12 years. I'm thinking I hope it takes a lot less.
What was the standard on the cul-de-sacs when he did his regulation? Was it?
50. We just had a
It was still 50.
It was straight 50.
That's right. That's what I was thinking that. Okay.
And he's
So-
saying he's gonna get 50 at the build line. He's gonna have 35 at the street.
Right.
The cul-de-sac lots are pie-shaped lots. I mean, we did that.
Didn't we move our cul-de-sac back to the?
The interior curves and the knuckles.
None of the knuckles have issues that we've seen. It's just the wide curves.
Those are a little harder to imagine because they can look like different things depending on how the land plan comes out.
They also end up being the largest lots in the subdivision.
Certainly, I think you could limit your variance to a percentage or a number if you to make that proposal. Or if you guys wanted to put that in your motion.
I mean, I hate to do stuff on the fly.
Yeah.
Just pull a number out of the air and say, go do this. So.
And I hate to give a blanket on it too. I mean, you know.
I'd like to see-
a bunch of them, you know.
Strictly on the
How
cul-de-sacs
do you
or
guys
for the
feel
whole?
about 10%? That no more than 10% of the lots in any subdivision, in any section, can't or can be below 50.
I'm gonna be like Ronnie. I like to look at it. And I'm not trying to be difficult, but I want to look at it.
Yeah.
You know, to say we want 10%, 20%, 5 of them, 7 of them.
Right.
I don't.
Well, yeah, I mean, if you're looking at throwing out a master plan on this deal, which I think is your ultimate goal, then obviously you ought to know, huh?
That's the challenge is it's really hard to plan for variances when there's the unknown. We usually plan for only knowns, and so we steer the other way. Which we're gonna end up with some very weird shaped looking lots by doing that.
Yeah.
We want to have a very nice interior road layout that the collector road concept with pod concepts, and what that does is it opens it up more in the middle where the main roads are, and it tightens things down just a little bit in the interior part, and that's where we have those little issues.
So if you're 7 out of 170 lots, what did you say?
It's a 10,
Out of 100.
70.
Even like
17
5%.
lots.
Yeah. You're like,
That'd be 17 lots. Yeah.
17. Does that sound like too much? But
Those to me.
Well, times 6 is 100 and over that.
But your situations are gonna change too, as your land lays out, your road lay out.
It's actually gonna kind of go away because if we get into the bigger lots, we're not gonna be making that ask.
Well, there's an idea.
Right, but 60 or 70, we won't ever see the 80-foot lots. That's really why we're here.
So it's really, I think it's like kind of like 2 questions and maybe you want to split them out. Is we talk about his standard residential lot width and let's slay that beast. And then that gives him some direction on his cul-de-sacs to go back to and say, hey, I can bring you something back because you're not gonna know what to do until you.
Well, I mean, I don't want to step in, but I'm not even hearing an objection on the cul-de-sacs. I think the question is more about the curves and the knobs. Right?
Yeah. I don't have a problem with cul-de-sacs.
Yeah, even those, I mean, whatever, it's any curved area.
If it's okay with you, could we just bring it for the cul-de-sac and we can take out the curves? And we'll plan around that. We'll make sure we're not asking for that.
Or you come back once you have a little more detail.
If it
You can bring it back with more detail. I just want more detail. That's all I'm asking. You know, show it to me and we're gonna make this curve because it's gonna be aesthetically pleasing around this creek or pond or whatever. But show me what you're talking.
Okay, all right.
Again, I'm not against it.
I just don't like a big blanket.
Yeah.
Specifics. Where you at, Brandon?
So 12 years, too much.
Well, it's basically for the life of I mean, this is a holdover project that was in the books and we knew we were gonna have some of these that were in the books before we changed it. And, now it's going, we don't have any more of these at all, really, Andy, do we? That were
No.
in the books before we changed it over, so. He's basically saying, can I build this subdivision out? I mean, I don't know about even putting a time frame on it. I mean, you're either gonna approve it and say, yeah, you can do 50 feet for those lots. Or I don't know the reason. Like I say, 12 years is just a big, huge number. I mean, you'll still be here probably to talk about it. We probably won't.
Well, I mean, you can't start, to his defense, I guess, you can't
Yeah.
start a subdivision with 50 and then go to
Exactly.
a bigger number.
Exactly. Yeah.
Especially when you only have two ways in.
Yeah.
And there may, if you had a backside, maybe not, but
I'm good with the 50 feet just for the life of the project.
What do you think, Brandon?
We're in the books before we changed our regulations.
We think we're discussing period of time,
Yeah, he's asking for 12 years.
Well, I
The project's under the old regulations anyway, so I mean. the
To give you
reality
to give you an idea, like, it's a pretty good sized project. How many sections are you looking at? Six. Six. But to give you an idea, like and it's a different model, it's different type, but like, let's say we did build out on the first group of sections in TGR in about 8 years, something like that.
But I can't see him being able to make any money personally.
Kind of
Yeah,
like, you gonna come back in 5 years, well, I submitted this and this. It's still that, you submitted it with those regulations.
It does, I'm advocating that it has, everything that you guys do on variances has some time limit on it. Otherwise it pops back up in 20 years.
Yeah.
Another court that didn't know about it, right?
Right. So work with me here on this one.
Okay.
I'm thinking 5. You're at 12.
I can't do it in 5.
Okay.
I can't. There's no way I can do it in 5. That would be just overlapping. There's no way. I could do 10, then we could do 5 sections, maybe. That way we're still planning every 2 years.
Well, and even if it did run out, whatever that time is, it still gives you the option to come back and ask for an extension or whatever, but it would be at the discretion of.
Yeah.
About 8.
He wanted 0. He wanted lifetime.
No, that's just Bill.
I mean, that's what you're going to do.
Yeah.
That's what you're going to give it to him for the lifetime of the project. So say 10 years, and if he runs out in 10 years, come back.
Come back.
And I mean, I'm good for that.
And to get it done as fast as possible.
Yeah.
Yeah.
Honestly,
Andy, that I'm missing.
There's one more, that's lot sizes for lots where there aren't homes on them, lots that are gonna be owned by the HOA or the MUD district. So right now, the current regulation doesn't denote a difference between a residential lot and a landscape lot or a drainage lot. And that creates an issue. We have, especially having a MUD district in place, we have a lot of opportunities where we need to designate reserves that are going to be maintained by the district or landscape reserves by the HOA. And if we have these odd shaped reserves meet the guidelines, then we lose the reserves and we end up making easements on back lots, which discussing with staff, that doesn't seem like it's a good solution for us either. So what we'd like to propose is reserves, lots that are platted as reserves. And we're not talking about commercial reserves. We're only talking about open space reserves, drainage reserves, things that don't have structures on them, where there's no lot dimensions to them. And could you go to the plan?
About number 33.
Sure, whichever one. Let's see here.
That's 33.
Phone coming down.
No, that's not me.
No.
That's where we ranch.
There you go.
Okay, so
This is,
No, I'm sorry, 32. You're on
yeah,
32.
scroll down there. There you go.
Okay, all right. The best example I can give you is, this is Peach Creek. And Peach Creek, we have called it out to be a separate, its own drainage reserve down Peach Creek. And we buffered that to make sure that nobody's down in, there's very little floodplain, if any, because it's the top side of the watershed. So, that lot, if you call it a lot, I call it a reserve, but according to the regs, it's called a lot. That lot doesn't meet any kind of lot width to depth. There's no way to do it. Because what it's going to look like, it's going to look like this all the way down. It's going to stub out right there. So it doesn't qualify. So the way for us around that with the current regs are to not have it as a separate reserve and to have it as a drainage easement behind lots. Why we don't like that is we want to have a clear definition of where somebody's lot ends on a creek and making sure that they're not intruding into that creek area. And we also want to designate that entire reserve to the mud district or a POA to maintain. And if people think they own to the middle of the creek,
Yeah.
I don't know what they're going to do, but I won't be able to control it. They'll go build a shed or a deer stand down by the creek. Where we want to make sure that they know that their lot ends right here. There's a buffer and these drainage reserves are protected. Same thing as maybe a landscape reserve up here at the front. We've got a boulevard entry here. And we have some L-shaped landscape reserves for buffers along 150 and buffers as you come in the property. And that particular reserve, there's three sides to it. There's the side in the cul-de-sac, the side on the collector road, and the side on 150. So nowhere do those lots conform. We have some open space reserves along the collector road through the property. Same thing holds true. So what we want to do is specify that anything that's a landscape reserve or a drainage reserve doesn't have to have a lot conformity.
Right now, our code has a lot requirement, and the lot requirement applies to any tract of land that is separated. So we don't have a conditional for what he's talking about. So if you want to put a landscaping reserve in, doesn't meet the minimum frontage requirement, then you can't do it. If you want to have a small landscaping sign that's on private lot, that's on a lot, not an easement, and the lot that you're creating, the tract that you're cutting off doesn't meet the minimum lot requirements, you can't do it. The only danger in it is, and I think there's maybe a way to overcome it. The big danger in it is you create these lots now, they belong to the POA. The POA transfers them at some point. The POA falls apart, somebody else buys it, and then they build on it, do something on it, put a structure on it. So my advice is if the court's considering approving this portion of the variance, that they require that the restrict notes, no structures, they're restricted to drainage, landscaping, infrastructure type easements. And that be recorded in a note on the plat and in the restrictions.
But there again, in conception, I love it. I like it. It's great, especially on the creek. You don't have own to the middle of the creek. I do think it's a great idea. But like Andy's talking about, what happens in 20 years? POA's defunct, property taxes not paid on that reserve, and then somebody swoops in there and buys it.
So
where are we at?
Yeah, so the mud district is probably the bigger entity to think about here. The POA will have small landscape reserves, and the mud district will have all the drainage reserves. So all those big ticket items that are actually not just being mowed and weed eaten on a weekly basis, but we're talking about being maintained. Those things are all going to be controlled by the mud district, and that's not going away. That's the taxing entity that has a board of directors. It's not me, and it's created through the state. So
if a mud district, if we allow them to put 20 acres in this mud district, and not a government entity, this property now belongs to that mud district, who pays taxes? We're taking that off the tax rolls?
I would imagine the mud district being a government he does it in Texas.
No.
I'm not an expert on that, but I.
It's like Elkton.
No, all the reserves still pay county taxes. And then there's a mud tax collected for the mud district from all the
But he's
homes.
saying that the lot's actually owned by the mud.
Well, it's not, I mean, I'm talking about
Who's gonna own the reserve?
the drainage reserve will ultimately be the mud district. And they'll maintain it. Or the landscape reserves, the smaller ones, these little, these tips, if you will. These open space tips and everything would be the HOA.
Again, it may be a place where the court wants more information.
I mean, how do you not let this happen though? I mean, what are you gonna do? It's a running creek, for goodness sakes. You can't plat it as a conforming lot.
There's a way
That's what I
around.
said,
No.
I actually,
I mean, I think it's something I think we need to look in our subdivision policies and put something in there that addresses that says if you're gonna build a landscape lot, a park lot, a lot for drainage or whatever, that doesn't have to comply to our subdivision standards because they're not gonna build a house on it. They're not gonna occupy it. It's a creek that's 500 feet long.
You understand, Bill, for the bulk of the history of development in this county, this hasn't been something that you guys have even seen.
Well, I understand that. I do understand it.
Mostly.
I understand. What I'm saying is, it's a reasonable, we don't have an alternative to it. We don't. What are we gonna do? We don't have an alternative. So I think what he's bringing is the best possible proposal with the best stability. A mud is like, say, it's a taxing entity that's going to stay in business what they do.
The HOA will also.
And the HOA, well, I know HOA is going to ditch. I got quite a few of those, but I'm more.
Flood district has to-
you say what I'm
Yeah.
worried about.
I understand that. I think there's always a possibility, like I say, that the HOA stuff fades away. I feel better about it now than in new stuff. But actually, I've got some old ones that are neck deep in trouble on POH.
But if in this case, if you have 600 plus lots and you have a mud district,
Right.
HOA's not going anywhere. I mean, HOAs, historically aren't failing in mud districts. That just doesn't happen because if anything, the mud district would take over.
Right.
So it's not gonna happen. Mud districts have a lot of authority and some of their authority is also Parks and Rec authority.
Yeah.
And they can actually come in and they can spend money on taking care of parks.
Sure.
And maybe it's because HOAs have.
And
not-
so the proposal to have basically a non-conforming tract, for lack of a better way to say, non-conforming tract for non-privately owned areas makes sense to me. I mean, why would
Yeah,
you?
as long as you're putting it on the plat,
Yeah,
you know, and.
that you
and
anchor that, deed
specifying
down,
it.
that you
Yeah,
restrict it out with no structures.
We would normally just call those reserves.
Yeah.
And we specify them in a reserves table in our plat, open space reserve, landscape reserve, drainage reserve.
Yeah.
It's very clear and they're restricted. So not only is it on the recorded plat, but it's also in the restrictions.
Yeah.
And if it's all recorded in the restriction, because you can have all different kinds of. You can have a reserve on a plat, but you can come back and develop later on, right?
Yeah.
So as long as it's all recorded on the plat. And
Yeah,
the restrictions
perennial.
are recorded on the plat.
Yeah.
Then you may accomplish what both of you.
Yeah,
But
it's a
the
perennial
critical-
restriction that stays with the plat.
Undervote.
Yeah, absolutely. I think that makes it.
And I don't know that I would, just thinking forward, is any of this for park space?
I don't think we have to worry about
Potentially.
that park. The park is 5 acres. So I
Yeah.
don't think that's an issue.
Okay.
Um,
Because the only thing, other potential is if you limit it to no structures, you may want to say no residential or.
Yeah, no
commercial
residential. I mean, that'd be,
Yeah.
You might need a bathroom.
well, I think we have a top park in there too, which is a small little park. And so that's a half.
that's why I think at our level, we need to get language in our subdivision regulations. So when this does come back, we can say, oh, yeah.
I'll give you another
We've
example.
addressed that.
I appreciate you bringing that up. Some of these lots through here have a drainage easement going between the lots. Okay, so some neighborhoods, maybe acreage communities would just put that drainage easement on the lot and call it a day. Well, one thing it does on a small lot community is it then intrudes into your building space on your small lot. So what we like to do is make it a drainage reserve, not an easement. And that way that drainage reserve is also maintained by the mud.
Right.
And it's not intruding and taking away from the lot width. On a 1 acre lot, it's not a big deal. If you have a 10 foot drainage easement, but on 2 50-foot lots, Well, you want everybody to get their 50 feet and you still have a drainage reserve, but that drainage reserve that's now only 15 feet wide or 10 feet wide doesn't meet the regulations.
Right.
But we want to make sure that it's maintained properly, so we want it to go to the right entity. It's nothing worse than going to a property owner and saying, you're not taking care of that drainage easement the way your neighbor does. You mow it and you don't mow it. So we want to avoid that.
Right.
What about Brian?
You're writing over there.
Yeah, well, this variance also has a lot in it.
Yeah,
So, here's what I've got to recap. I think this is what I have. Yeah. So the period was 10 years. Or, I know that a motion has been made, so I'm just giving you back what you guys have been talking.
Have we made a motion on this?
No, he has not.
No.
I don't think we had a motion on this.
It's been in discussion.
So the period that was discussed was 10 or possibly 10. The developer understands that the future sections will be subject to the regulations in place at the time of the application, with the exception of the variances to lot frontage and depth. Just say variances granted herein. You also are looking at the reserve lots. Allow 35-foot minimum frontage for cul-de-sac lots in compliance with the application at 50 foot at the building setback line. But not for knobs and curves at this point. And then allow for reserve tracks smaller than allowed in the policy to be transferred to MUD or property owners association for drainage, landscaping, easements, as long as no residential or commercial structures are placed on it. Is that a recap? Okay, that's what I've got.
Think so?
That's
You want
the
a motion?
And that's the recap, and that's my motion.
Did you write that down, Andy?
In the process of it.
I got part of it.
I did write it down, but I don't know if you can read it the way I wrote it.
I can probably decipher.
You all right on that, Brandon? It's a lot to decipher.
Cause I got the 10 years, deliberation against future sections will be subject to
good?
the regular place.
At that time.
I think it's different.
Oh, wait, yeah.
After everything. It all started brand new. It all, I mean, I'd still vote. Get for it, but those 80-foot lots, I don't think we'd be as sympathetic towards it, because that's just.
Yeah.
Back then, it wasn't the rule we started, so.
If we was operating on the old policy,
35.
with the exception of the HOA and the mud stuff and the cul-de-sacs, would you even need a variance?
Nope.
On the
Why,
cul-de-sac.
why are we putting the time frame on it?
That's what I said, brother.
I mean, I know what you said, but if we just basically put it under the old policy, said it's under the old policy, you wouldn't be asking for a variance, right?
Yeah.
Not.
With an exception of cul-de-sac.
Yeah, but this kind of gets it in wording that it's modern day, and we're looking back saying we're giving the variance to the new standards because.
Well, and you still had the reserves that were putting in there. None of that was in our old
Right.
policy.
We're gonna get something in there with that though.
Yeah, it needs to. I mean, so he would still have to come back on the reserve lots, either way.
Yeah.
And the mud district is
Drainage reserve
totally
lot.
throws it up in there anyhow. I mean, that's what's different from everything else.
I don't know, seems like a lot, still don't like it, but. Don't mean I have to like it, right?
Not in your precinct.
I don't like it a lot. Right's right, wrong's wrong.
Probably be happy if you put gates on there and made it private too.
Huh?
Yeah, is this gonna be private or not?
No gates.
No good.
I don't think.
Too many
fire-
people.
I don't think the fire
Too many people. And I'm assuming, what I forgot to ask you a while ago, I'm assuming though that you're gonna have turn lanes and everything from the highway.
Oh, yes, sir. We already
Yeah.
did our traffic study. Right turn lane in the first entrance. And then, a center turn lane on 150. I believe after 150, 150 homes, center turn lane.
Period of 10 years.
All right.
Good deal.
That's a good size subdivision. I like the fact they're doing their own water well.
Yeah.
Doing their own water supplies. That's nice. One big well.
Are y'all doing your own water supply?
In my district, well, that's it, that's.
Yeah.
Right here.
We don't know on the water yet. We don't know if the mud will own the water or if a private utility company will.
But you're gonna drill a well and have your own water plant, and stuff like that.
100%, yes.
Okay.
Yeah.
Okay.
And our own, obviously our own, sewer system.
Yeah.
Make sure.
There
Awesome.
won't be 600 wells or.
That's nice. We like that part.
I definitely like that part.
Well, it can't be.
I talked to a lady a while back in New York, and it was her water well went kaploop with all
All
the
right.
surrounding things going on.
Got all that you read, Carrie?
Didn't get who seconded.
I'll second it.
Got a motion and a second. All in favor, raise your right hand.
I'm reluctantly raising it.
Motion carries.
Thank you.
Thank you, Mr. Rim. Number 33, discuss and take action on West Waverly Ranch LLC request for variance to section B 12.10 A of the Walker County subdivision regulations regarding roadside ditches, 6 inches of freeboard for plat number 2022-035, Homestead Hill subdivision, John Sadler survey, A45, Steniak Road.
So we have a requirement in our code. Board in the ditches. Designing for storm. The application here is to allow, not eliminate the. Review, by Law Associates. The review of this project. By the way, I want to apologize. I in error. Mentioned Lyle last project. They're not the reviewer. That's a team this project.
Yeah, I did read that.
Well, apologize for that. If I confuse anybody. The engineer for the developers here, and Stephanie is also available online. But essentially, Stephanie, you have any conditions? I think it was just to contain the 100-year.
Correct, yes. So their variance they submitted indicates that the 100-year will be
and,
contained within the high banks, and so that would be a condition of the approval. I would recommend it, that be the condition of the approval.
Did they send, I mean, Ada, did they send you anything that allow?
Yeah, they had one condition.
Like she was trying to speak.
I think it was just that it contained the 100-year flow, which I think is the proposal.
It does. I don't have any problem with this.
You good with that one?
I'm good with this.
Okay,
Motion.
for that.
Yeah.
There you go.
I'll second.
This is Diego Espinosa. He's the-
We've
Been here before, yeah.
no, it does contain the 100-year within the proposed swell that we have. We're just limited on space before the property opens up.
Small.
And it's the worst case scenario, we're short by a little bit over 2 inches out of the 6.
The only part I don't really like, it says we believe the county will be negative affected. It was, a little more. Hey, we know the county's not gonna be. But I'll give him a second anyway.
All right, moved and seconded. Anything else? All in favor, raise your hand. Motion carries.
Thank you very much.
Yes, sir. 34, discuss and take action on application requirements for the John Stubblefield Development on-site sewer facility permit number 2023-0439.
Where we at, Andrew?
We're trying to get this thing permitted. Mr. John I believe passed away. So we're having a hard time getting to an owner record, like, through our normal documentation process. The current application that we have, the owner is the current occupant is a sister of John, but she doesn't have what we would normally require from owners to prove ownership. So the only way I know to move forward is if the court were to authorize me to issue the permit without my normal documentation. So normally what we'd have to have is either a deed or,
It's probably still in the family, right?
or something like that to prove ownership. But I know it's an ongoing issue, and I know that the court granted the grant to get it resolved. And so I'm still seeking to do that. I don't want to hold it up forever over this issue, and it may take them some time to work this out. So the only thing I knew left to do was to bring it before the court, see what we could do from here.
This is the one on Seth Grant's.
Yeah.
Yeah, this is on the Seth grants, and I don't think there's a whole lot of documentation that Seth needs, right?
I don't need any.
I don't think they need any, but to move forward with it, Andy, what do you need from us? Because I mean, the reality, John and his sister have lived in that home for years. And it's probably still in the family name. Is that correct or not?
It's still
Parents,
All right, that's the last deed that we have.
Was the parents?
Parents, right?
that's been a long time ago because I remember them.
Is that the John used to work for the city? John, Big John and Little John?
That's the group, yes.
Okay.
One of them was a deputy sheriff for a while, wasn't he?
That I don't know.
Will might remember that. I want to say he was, but
I mean, we are talking about repairing an existing system and doing.
yeah, the system's failing big time.
Oh, that's one right across the property line.
We got many complaints on.
Oh, yeah.
Yeah.
Okay. Let's fix it.
Let's go with it.
So what you need, just us to say,
Just authorize me to move forward, with the current occupant, allow them to sign the paperwork for the.
that's my motion.
I'll second that motion.
Moved and seconded, all in favor, raise your hand. Motion carries. 35, discuss and take action on Michael Durr request for variance to section B 2.2 of the Walker County subdivision regulations regarding lot depth to width for plat number 2023-048, Michael Durr 30.14 acre tract. Lemuel M. Collard Survey A10, Jones Road.
Andy, this is one I was telling you, over the weekend, I got phone calls about some boundary discrepancies, and I'd like to ask at this time to have a little more time to research this.
So, the application is on frontage. Whether or not they can, inspect the width and, get a variance. Yeah, your concerns are what is the actual frontage. And my suggestion would be to, if you want to pass on it or if you want to deny it.
The
So we
surveyor
don't
is also,
know the ability to do what?
the surveyor is also online saying he's available for question.
Who is?
Surveyor.
Surveyor.
So you got some questions on the property line?
I do. We have some, I had some phone calls over the weekend that wondering exactly where the property line is in reference to the fence.
Talking on the Pedraza side or.
House side.
Okay.
This is Matt Tucker. I'm with Texas Professional Surveying. I can try to clarify some issues during this meeting if need be.
Barely hear him.
Are y'all able to hear me?
I've got Thomas McIntyre as the ceiling surveyor.
Yes, Mr. Whoever
Are y'all-
here is online?
Is the room able to hear me? This is Matt Tucker with Texas Professional
You're really
Surveying.
one.
You don't want to deny, I want to make a motion to deny with the ability to come back to court.
Second.
Moved and seconded,
And just so I can pass it on, additional information relating to the fence and the property line
Fence, the property line.
along Draws Road.
moved and seconded, all in favor, raise your hand. Motion carries.
Wow.
No more executive session. Any public comments? Questions from the media? Commissioners Court?
And Wade, you stayed this whole time?
I make a quick statement. I don't know if everybody knows or not, but we did not get the courthouse grant for the sidewalk. I'm working to set up a phone call or whatever conversation with them next week or two to discuss how we're gonna fix it. They were.
Ronnie.
Yeah.
All right, anybody else? Move we adjourn at